Hello, colleagues. Welcome back. This is part two of the risk management and insurance presentation. In this section, we'll deal with specific risks. We'll start with the risk of clients. Be aware of those who have unrealistic expectations. These are the type of clients who expect lawyers to perform magic where it's not legally or practically possible to perform such magic. These are the type of clients who expect you to sail close to the wind and put your professional reputation on the line for them. And those who have terminated the mandates of one or more attorney in the same matter, you should also be skeptical about, ascertain that the reasons for the termination, and weigh up whether or not they are valid. Those clients that are heavily invested in matters, want to litigate on principle or want to dictate every term and the strategy, are also a risk, because they will not respect your independence and will want you to do things their way rather than apply your expertise or do things according to the law. It's the same with those who want to win at all costs. If you don't get them the results that they expect, despite your hard work, they'll say that you failed them and could either sue you or report you to the regulator unfairly. And those who want to co-lawyer with you, these are the type of clients who've done a search on the internet and found anything vaguely relevant or not to the matter they've instructed you in, and want you to follow those, and they also want to tell you what the law is in matters. Clients who dump a lot of documents on you and expect you to figure out the case to be made or whether or not the documents are relevant are also a risk. They could just be passing a bag of snakes onto you, so to speak. And also be careful of clients that tailor make their versions to suit the case that needs to be proven, and clients who sometimes magically can produce documents or witnesses that did not previously exist. Always be mindful of your ethical obligations in matters, and also be mindful of those who are needy in respect of your time. These are the type of clients that can phone you at any time, expect you to be available to take their calls and to discuss matters with them for as long as they want. Clients who show up at your office without appointments, and those who bombard you with email communications and text messages and just expect you to always be at their beck and call. And also be careful of the serial litigators who are fundamentally unhappy with the administration of justice, who have a history of conflict with lawyers, those who have a history of reporting lawyers to the LPC at a drop of the hat. These are also the type of clients that are quick to run to the media and to also post on social media defamatory allegations about lawyers. Be very careful of them. Just for clients who have terminated the mandates of previous attorneys in the same matter, please have a look at the code of conduct to see what the requirements are on taking on a matter where there is another attorney on board in the same matter. Letters of engagement. This is just a contract between the law firm and the client. It sets out the terms of what the law firm is expected to do, the obligations of the respective parties, issues regarding fees, etc. Remember, we said in part 1 that sometimes clients frame their claims against attorneys in contract, alleging that the attorney has breached a term of the contract, and then there's a debate regarding what the terms of that contract are. You'll note in the Hartog versus Daily matter that we'll mention later when we deal with cyber crime, that one of the issues was whether there was a tacit term was part of the contract between the parties. The scope of the engagement, this is what the firm is instructed to do. Set it out as detailed as possible and in language that the client can understand. This will help to assess whether you and the client have had a meeting of minds, whether you are at idem on what needs to be done, and it will help you to also understand whether what you are expected to do constitutes legal services. Look at the clause defining legal services in the Lpiif policy. That's Roman numeral 22. So Roman numeral 22. So it's XXII, and then also look at clause 1 of the policy. If what you are doing does not constitute legal services, the Lpiif policy won't cover you. Top-up insurance policies also have similar clauses. Some use the expression legal services, others use conduct of the profession, but it's the same. If what you are doing is not legal services or the conduct of the profession, the insurance policy won't cover you. Also look at section 55 of the Legal Practice Act. If money is stolen by an attorney and the attorney was not conducting legal services, the Fidelity Fund won't indemnify the claimant there. Some examples where common examples where there are disputes is in an RAF claim, the attorney acts, and the attorney's understanding is that they need to pursue a claim on behalf of the client against the road accident fund. They pursue the matter, obtain compensation for the client. The client says, "Thank you very much, but you did not pursue a claim on behalf of my children who were also injured in the accident, or also had a claim arising out of the death of the breadwinner." And the attorney says, "But I was never instructed to do that." The client says, "You were. You did have a problem." It's the same with an RAF matter. You pursue the matter, and then the client comes back and says, "But what about the damages to my vehicle?" The attorney says, "I wasn't instructed to do that." The client says, "You were." Similarly, if there are criminal charges flowing from the accident or an inquest, does the client expect you to deal with those as well? In matrimonial matters with divorces, is your mandate only to pursue the matter up to the stage where a decree of divorce is granted, or are you expected to do any additional work after that? Are you expected, for example, to deal with the transfer of a property or a half share in immovable property if it formed part of a joint estate? Are you expected to deal with claims in respect of the pension? You do not want clients coming back to you long after the divorce is granted to say that you didn't pursue my interests in the property and my former spouse has allowed it to fall into a state of disrepair. My former spouse has now sold it. You don't want clients coming back to you to say that you didn't pursue my claim for my share of the pension, and didn't enforce my rights in terms of the clean break principle, and therefore now I'm looking to you for help. And you say, "But I was only instructed to act up until the decree of divorce was granted." In commercial matters, you'll recall from Part 1 has said that in times of economic slumps, clients sometimes look to make up any losses they haven't made in the commercial market by suing their lawyers. If you are instructed only to draft agreements, specify that. Don't want clients getting into commercial relationships. When things don't work out for them, they come back and sue you and say that you got me into a dud commercial deal. You didn't do a proper due diligence when that was never your mandate. So be careful of those. Record if the client is instructing you in a representative capacity. That's if they a parent or guardian of a minor child or someone who cannot attend to their own legal affairs. If the client is a representative of a company, get a resolution that has been signed by the directors of the company, authorizing the person to instruct the firm and also to act in the matter. Curators, get a copy of the court order. You don't want people turning around later and not paying your bills and saying that you were not authorized to act in the matter. Also, a lot of times when there are fee disputes in the matter and the attorney sues the client hits back with a counterclaim alleging that the attorney did not do what they were supposed to do. Client identification and FICA, this is very important. FICA should not be a tick box exercise. Do it properly and follow both the spirit and the letter of the law. Explain who the servicing team is at the firm. That's who will deal with the matter. If it's a litigious matter and you expect to use counsel or experts, say that. It's also a good thing to explain to clients in litigious matters or any matter about how long you'll take to finalize the instruction. Fees and billing, set those out in how you charge, whether it's on the tariff, whether you have an hourly rate, whether it's an agreed fee. Record that, because you don't want fee disputes later. And those section 35 subsection 7 to subsection 12 of the Legal Practice Act haven't come into effect yet. The implementation has been postponed. They contain useful information that you could use in your contract. So please have a look at them. If you're acting on a contingency fee basis, set that out. Ensure that the terms of the contingency fee agreement comply with the Contingency Fees Act. Importantly, remember this when we deal with cyber risk. Provide the details, the firm's banking details, and get those of clients. Insist that the client gives you an original bank statement document setting out their banking details. Remember this when we get to cybercrime, because there's always a risk if banking details come later. Also explain under what circumstances the relationship can be terminated and the consequences thereof. If the firm will have a lien over the file, if the client will be liable for work done up to that point, rather say it. Dispute resolution doesn't have to be complex. You can say that in the event of a dispute, within the firm, it will be escalated to somebody senior, head of department, senior partner, managing partner, whatever the position is. The client, if it's a corporate entity, then you're dealing with a legal advisor, that the dispute will go to the head of legal services, general legal counsel, whatever the case may be. If there are other counterparts of the agreement, record that. Ensure that all the parties sign and date the agreement. We have lots of instances where a firm drafts a letter of engagement, sends it to the client never signs it and sends it back, but because the firm just carries on doing the work. That is very dangerous. Explain to the client that you will not start work until the document is signed and sent back to you. As things change when you're executing your mandate, prepare addendums if necessary, as and when the circumstances change. And likewise, get everybody to sign and date them. When do you deal with those? What I've also written in the August 2024 edition of Dairabos on the risk of scope creep. Scope creep is where a client instructs you to do one thing, but over time the client keeps adding new instructions on top of that, and before you know it, what you're doing for the client is vastly different from what was initially agreed. So beware of that risk of scope creep, and read that article published in August 2024. If your firm doesn't have letters of engagement, these resources referred to on slide 18 will assist you. Prescription. As I mentioned in part 1, prescription is the greatest risk faced by the Lpiif, both in terms of number and value of claims, and we need to find ways to mitigate this risk. I just need to mention that if you have a prescription question in the assignment, please do not just copy and paste what is stated on this slide and the next slide and put them in your assignment and try and pass them off as your own work. That will be plagiarism. You'll score 0, and plagiarism is dishonesty. So don't do that. You'll see in the manual that there are also several prescription mitigation measures suggested. We've written more about prescription and cybercrime than any other risk. So, and I promise you, because I've written a lot of this, certainly written all of it since 2017, I know what I've written, so I'll be able to identify it if somebody tries to use it in the assignment. Be careful of taking on too much work. In October 2024, I wrote an article that was published in Dairabos that deals with the risk of taking on too much work. But ask yourself, do you have the appetite, resources, and expertise to pursue the instruction? Check if the client has provided you with all the necessary documents and information. Register your matter with the Lpiif's prescription alert services and adhere to the reminders sent out by that unit. Take full and detailed instructions at an early stage of the matter. Don't consult with the client today and say, I'll get back to you, and go on and get busy with other areas of your practice, and then in many months from today you say, oh, I've still got that matter, then let me go back to the client. The prescription clock is running. Act promptly and do not procrastinate. Supervise staff and check that all matters are attended to timelessly. Don't only take their word. Regularly review files. File audits will assist. There's a file audit template on the Lpiif website. Inform the client timelessly if the matter can't be attended to. Record this in writing in a file note on the day you speak to the client, and send correspondence to the client confirming the discussion. If a prescription date is looming or there's some other step that needs to be taken, point it out in the correspondence sent to clients so they don't say that you left them in the lurch. Educate all staff on the prescription periods. Be alert to statutory notice periods for claims against the state. If you're doing personal injury matters, I think it should be compulsory reading for everybody in a personal injury practice to read this judgment in Shoprite Checkers versus Mafate. Study with the law so you know when prescription begins to run, when it's suspended, and when it's interrupted. That will help you if you're faced with a special plea of prescription and you can overcome it. There are those people who just throw their hands up when they get a special plea of prescription and want to give up and don't ever test the veracity of such a special plea. I've mentioned reviewing files regularly. Files that have had no action and no developments, close them after you've advised clients. Implement a peer review system. This just means that somebody other than the person dealing with the matter will look at the file. It's good when a fresh pair of eyes looks at something. We've adopted that from the auditing profession. They use a peer review system where a partner other than the person involved in the audit usually checks and audit reports before they go out. That helps. Fresh pair of eyes will assist. Just on files where there's been no activity. In one of the books that I will give you at the end, that I'll refer you to, sorry, at the end of this course, the author makes a suggestion. He says that in his firm, you take files where there's been no action, and he'll read them if he's dealing with it, and he passes it on to someone else if he's still got it. The rule is that the person who receives it needs to read the file and do something in a period of, say, 2 weeks. And if necessary, pass it on. You cannot pass the matter on without doing anything. And it says in that way that it helps to revive files and it avoids prescription. Don't assume that prescription is 3 years in all cases. Remember, in RAF hit and run matters, those are cases where either the identity of the owner of the driver of vehicle is unknown. It's a 2-year period. In 2019, the Lpiif successfully challenged those regulations insofar as they relate to minors or people under some sort of legal impediment. Design a dual diary system with your secretary, a candidate attorney or paralegal. This just helps so that nothing slips through the cracks. If you're not available on a specific day, that somebody knows that matters need to be attended to. Ensure that you plead the correct cause of action, that you institute action out of the correct court. You don't want to run a matter for 4 or 5 years only to be hit with a special plea that the court lacked jurisdiction, and then you want to restart the matter in the correct court. By then it would have prescribed. It will also help when you take detailed instruction from the client up front. You'll understand when the cause of action arose, because it will help when the client became aware of the cause of action. All that information will help you assess prescription. Be wary of tactics by your opponent. So if you're talking to your opponent and the prescription date is coming up closely, and the opponent says, don't issue summons, we'll settle the matter before then, don't take them by their word. Ask them to send you a letter, if necessary, extending the period of prescription, or agreeing that prescription will be suspended. Because if you don't do that, the day after the prescription date has arrived, they'll inform you that you are on your own because a claim has prescribed. And it's important to remember that it's the service of the process that interrupts prescription, not the issuing. A lot of attorneys get that wrong. Please read Section 15(1) of the Prescription Act. And remember that if you fail to register your matters on the prescription alert system, that's RAF matters, or to comply with the reminders, you'll pay a higher excess, plus the additional 5% for not using the prescription alert. That's Schedule B of the master policy. Remember that if you are faced with a prescription question in your assignment. Under settlements, as I explained in part 1, these are matters where a matter settled and the client then alleges that the attorney settled the matter for less than the compensation that they would have been entitled to. I've written an article on under settlements. I don't know when the Rebus will publish it. These articles are are produced well in advance of the publication dates, because they have to go through the de rebus process. So that article, I'm not sure when it will be published, but it will be in 2025. Can't tell you which month yet, but please look out for it. I've summarized cases, recent cases dealing with under-settlements there. Don't rely on your widely worded power of attorney that authorizes you to do a whole lot of things. Consult with the clients on every offer you receive. There's a case that you have been referred to in the manual, Goldschmidt versus Fobb. In that case, it's said that the principle that an attorney needs to put offers to the client, even if it's your recommendation to the client that the client rejects it. Remember the once and for all rule. Tell the client that if the offer is accepted, they cannot come back later after the compensation is finished and want to institute the same action against the same defendant. Be wary of clients with unrealistic expectations. It's clients who, in personal injury matters, sprain a wrist, but they expect to get 5 million in compensation when they are not even sports people or people who rely on the injured limb to earn huge amounts of income. I don't want to sound flippant about injuries, but it's just what happens in a lot of matters. So manage your client expectations. Ensure that you've properly addressed the quantum and obtain updated medical, legal and actuarial calculations. Doesn't help you to go into a matter with stale medical, legal reports and actuarial calculations from several years ago. Run the offer by your experts as well and get them to explain it, to give you their opinion. Be wary of pressures from clients, family members, and if necessary, when you're dealing with minors or people who cannot manage their own affairs, rather ask for a curator to be appointed, because sometimes clients just see the dollar signs and they want it immediately, as happened in the cases I referred to in the article as I said I've written. Leave the door open for the client to obtain a second opinion if they require one, but on that point, be careful of clients that go to another attorney and the attorney says that, oh, I can obtain you substantially more compensation, but the attorney is saying that without any real information about the matter, what the prospects are, what the injuries are, what the assessments are. So tell that to clients if they come back and they tell you that there's an attorney that promised them substantially more. And settlements at roll call court, and in the corridors at court are common and very risky. Often at court on the day of trial, the parties talk. That's their legal representatives. The plaintiff will put a figure, and they'll say is their base figure that they'll accept. The defendant will come back the defendant will come back with a lower amount, and then between the two legal teams they'll say, let's split the difference and settle on that basis. Phone the client and run the visit by the client and explain it to them. If you have updated medical legal reports and updated actuarial reports, you'll be able to make an informed decision there. Don't just take the money and run and think that because you are acting on a contingency basis, you've invested a lot of money in the matter and now you need to take something out, even if it means just breaking even. Do not do that. It's the client's matter at the end of the day. Commercial settlements are the same. These are people who say no for. It usually comes from defendants. Defendants like to say, oh, yeah, we've considered this matter, and just to we don't agree that we are liable, but purely on a commercial basis and on a without prejudice basis will give you so much, so you can go away. And some insurers refer to that as nuisance value. That's not us as the Lpiif. We settle claims fairly, because if we don't, the plaintiff's attorney will then be sued, and then it will still be our problem. And read those two articles. The second last bullet refers to a matter that an article that was published in 2018. The last one refers to the upcoming article that I mentioned. Moving on to theft. Please study the Legal Practice Act and the rules to know what your obligations are. And implement appropriate financial controls. In a lot of the matters for striking off, the attorneys alleged that they gave the controls to somebody else in the firm to deal with, and that they were busy running the practice, and they did not provide sufficient oversight over the financial controls, and therefore they shouldn't be suspended or struck off. That won't help. Know what your ethical duties are. If your practice isn't financially viable, consider other options. Close it. You can merge with another firm. Go look for employment in the corporate world. In an article that I've written a few years ago, I addressed the issue of why law firms fail. I think it's called something around lessons learned from law firm failures. Please read it if you are struggling in practice. Have a system of segregation of duties in place. This just means that don't have one person who can requisition a payment, authorize it, and then release the funds from the bank account. I know that we all rely on our bookkeepers or people with similar titles in the financial function, and the overwhelming majority of them are honest, hardworking people. But as with everything in life, there's a small minority who are the problems. We have a lot of claims reported to us arising out of theft, and as we all know now, theft claims are not covered by the Lpiif policy. However, when you read the facts, they make for some scary reading. In 2023, we were notified of a claim by a sole practitioner who worked for a long time with a particular bookkeeper. It wasn't a big practice, but the sole practitioner was trying his best to keep the firm sustainable. He gave his bookkeeper the passwords for his trust bank accounts, and unknown to him, the bookkeeper used the funds that clients were paying to start a poultry farm. There have also been numerous matters where people in the firm have given outside parties their own bank account details rather than the firm's bank account details. It also happens often with debt collection firms that specialize in debt collection, that the people doing the collections give their own account details. Please note, I'm not saying it happens to everybody, I'm just referring to the specific instances the way these things have happened. So do not give too much control to one person. Be careful of people in the finance department who are so dedicated to their work. They never take leave, never get sick, never have bereavements in their family, nothing. They can work every day and every night. It could be a result of their dedication or them just covering their tracks. And you can phone those types of people any time of any day or any night and ask them about a specific transaction that happened 9 months ago, and they'll be able to tell you what it is. Maybe they are just controlling the narrative or just ensuring that you never dig deeper to find the truth. That goes to the next point. To trust is good, but not to trust is very good. Don't accept documents and explanations on face value. Apply a level of professional skepticism. Once again, a term that I've stolen from the auditors. We were notified of a matter, also not covered by the Lpiif, of a firm in Cape Town. There were 4 partners in the firm. The firm also had a litigation and conveyancing department. The staff, it was estates and administration of estates and conveyancing. The staff dealing with estates came up with a scheme. They would go around to their communities. They'd find people who owed, for example, the city of Cape Town monies, and for a fee they said they could clear that. And their modus operandi was simple. They would get those people's municipal accounts, take them to the office. A lot of estates where there's a property involved need to pay the city council any amounts due. Instead of putting the deceased account in there, they put the account from the person that they got in their community. And they knew the routine of the partners. They go when one specific partner was at the office and the others were out, because they said that they knew that he wouldn't scrutinize documents carefully. So he looked through the bundle of documents placed before him and said, oh, the estate needs to pay the city council, and authorized that payment. By the time the firm realized what was happening, the perpetrators of that scheme within the firm had made off with more than 600,000 rands. Purchase misappropriation of trust fund insurance. Misappropriation of trust fund insurance, as the name says, covers you for theft of trust monies. Some people call it a trust monies policy. Also, when it comes to your business funds, that's your own fund, consider a fidelity guarantee policy. The use of the word fidelity in that, please don't confuse it with the fidelity fund. It's nothing to do with the fidelity fund, just a historical name for those policies that came down with the insurance industry over the years. Often in assignments on the theft question, I'll ask what type of insurances could the firm consider, and people often get it wrong. So remember, trust funds, misappropriation of trust fund policy. A business funds, misappropriation of own funds. Remember your obligations to inform the regulator in the event of a trust shortfall. You have to immediately inform the regulator and you have to make it up. Rule 54.14.7 has been quoted in the manual that prescribes the internal controls you have to have over your trust account. Read it. And finally, remember that theft claims are excluded from the Lpiif policy. Quoted the relevant terms of the policy there. Just going on to the fidelity fund, because unfortunately, colleagues, they find that there's still a huge portion of the profession that don't know what the fidelity fund is or what it does. People that think that the fidelity fund and the Lpiif are the same thing. They are not. The fidelity fund is an entity that's created in terms of legislation. The Lpiif, on the other hand, is an insurance company. The fidelity fund indemnifies those people, that's owners of money, who have suffered losses because of the theft of trust funds. The fidelity fund does not cover the attorney. If you are an attorney and you've stolen money, do not contact the fidelity fund to pay that money back. The fidelity fund doesn't cover you, it covers the client. if there's a question in the assignment, don't say in the assignment that the firm where the funds have stolen can claim from the Fidelity Fund. So on the other hand, the Lpiif does not cover the client, covers the attorney. The Lpiif doesn't cover theft, it covers a liability to pay compensation arising out of legal services provided. And so those are some of the differences. The claim procedures are also vastly different. So please read Chapter 6 of the Legal Practice Act. Check the procedure for lodging claims on the Fidelity Fund website. And remember that in terms of Section 55(1), the Fidelity Fund will only be liable if there have been funds entrusted to the firm. The judgment in Smith versus the Fidelity Fund that was handed down in December 2024 is the most recent judgment dealing with the test for entrustment. Please read it. It's compulsory reading if you're hoping to pass the assignment. Read it. There were 4 claims there. One claim, in respect of one claim, there was found to be entrustment in respect of the other 3 not. The courts explain what entrustment is, the intention or the importance of the intention of the parties when the money is paid. So please read that case. And as I've said, the Fidelity Fund covers the person who suffers the loss, not the attorney. It's a client protection fund, and it's a fund of last resort. Fund of last resort means the claimant will need to exercise all their rights against the attorney. In other words, they'll have to excuse the attorney in simple terms. It means they'll have to institute action against the attorney involved, and only if the attorney doesn't have assets, then they will, the Fidelity Fund will pay. The Board of Control, the board, because since 2018 it's not a Board of Control anymore, the Board of the Fidelity Fund can waive the requirement for excusation. The example I often give, if you have a law firm and it's stolen the money of 5 clients, and the first client goes through the process of excusation and finds out that the attorney has nothing, or the attorney is already in jail, you cannot reasonably ask the other 4 to go through it. The cases referred to in the manual also deal with excusation. So that's what's meant by a fund of last resort. As I've said, note the differences between the Lpiif and the Fidelity Fund. Check the timeline for the notification of claims and the pursuit thereof. Section 78(1)(a), the requirement to provide a written notice of the claim to the Fidelity Fund and the LPC within 3 months of becoming aware of the theft, or by the exercise of reasonable care should have become aware of the theft. Section 78(1)(b), the requirement to provide the Fidelity Fund with proof of the claim within 6 months after it has requested that proof. And then Section 79(1)(c), that an action against the Fidelity Fund must be instituted within 1 year after it rejects the claim. So, insurance for theft claims. I've mentioned a misappropriation of trust fund policy that mitigates losses due to theft of trust funds. Then theft of own funds and fidelity guarantee policy we've also mentioned. You can also look at buying a commercial crime policy for your firm, because some commercial crime policies also cover theft. Ask your insurance broker or intermediary about an employee dishonesty policy. An employee dishonesty policy also covers theft, depending on the wording. But when you speak to a broker or an insurer, don't just look at the names of policies. Look at the insuring clause and check if they cover what they are. Ask your broker to explain it to you. That's what they get paid for. And don't wait until you have a claim before you check the policy. I know reading insurance policies is tedious. It's like reading a manual for a TV. But considering the implications, if something goes wrong, rather colleagues suffer through it. And often in the assignments, there's a question related to insurance products for legal practitioners. If you want a short summary, read that letter in the August 2022 edition of De Rebus. It gives a short summary of the different types of policies. Going on to regulatory risks. These are the risks where the firm does something or fails to do something that results in it being a breach of regulation, and as a result there's some action, whether it's by the LPC, whether it's by the FIC, whether it's by some other regulator. If we look at the cases for striking offs, most of them, vast majority of them, relate to dishonesty. And theft is a big risk there. As I record this, I don't have the updated figures from the Fidelity Fund with respect to claims, because they are still busy with their year-end audit, and we'll get those once the annual report for 2024 is published. But last year the indication was that the Fidelity Fund was sitting with about 1.5 billion rands. That's billion, not million. Billion with a B, if you want emphasis. So it's 1.5 billion of contingent claims. That means active claims regarding theft of trust monies. That's a significant amount of money in almost anyone's language. So theft is a real risk. Another problem that you see from the cases and the actions that the Legal Practice Council has brought is also the manner in which practices are conducted and how practitioners deal with third parties. Colleagues, be careful, because if you go onto the Legal Practice Council's website and you can scroll down, I think it's the page for members of the public, there are details there that are published, and they are published in terms of Section 38 of the Legal Practice Act. You can see names, you can see names of individual practitioners, names of firms, what they are alleged to have done, what sanctions have been imposed on them. You do not want your name appearing there. And also you don't want a potential client going to search there and finding your name. So please do things properly. Practicing without a Fidelity Fund certificate is also a huge problem. Please read Section 84 and Section 33 of the Legal Practice Act. The FIC has issued significant fines to law firms in the last year and a half. Details are available on the FIC website. FICA compliance should not be, let me rephrase that. FICA compliance must not be a tick box exercise. Comply with the spirit and the letter of the law. Read the applicable rules. And also the LSSA, the Law Society of South Africa, has the FICA resources on its website that can also assist you. Read, when it comes to payment of monies, read Rule 54.13, that's 54.13. This rule says that trust monies must be paid out as soon as possible, and before you pay out trust monies, you must verify the banking details. This is a huge problem when it comes to cybercrime, which we'll talk about later. And it's another reason why the LPIF won't pay cybercrime claims. Remember, we said that it's excluded in terms of the policy, but if you make such a payment, you're making it in breach of this rule, so therefore you'll be out on that ground as well. Premature payment of funds are mentioned in Part 1, Please read those at paragraph 14 of the Code of Conduct for Legal Practitioners, and also read paragraph 34.6.1 of the Code of Conduct for Property Practitioners. And we've covered 4 scenarios in the document that I've referred to that's on our website. There's a link there. You can also use it. You can use those 2 points if you need to bat away an estate agent that wants to monies, the commissions paid up front. And then there is an article in one of the previous editions of De Rebus on the importance of a compliance function in law firms. So please have a look at that as well. Just a few additional points on regulatory risks. Only use regulated entities. So if you're an attorney, and for now we're not talking about those colleagues who are practicing for the Legal Aid Board and at the South African Human Rights Commission and at university law clinics. We're talking about those practitioners that are in private practice or running commercial practice, as it's referred to in the Acts and the rules. So you can practice for current purposes as an advocate with a Fidelity Fund certificate. We're not going to talk about the referral provision because it's not relevant to us here. Or you can practice as an attorney. An attorney can only be a sole practitioner in partnership with other attorneys, or in an incorporated entity, or where all the directors and members are also admitted attorneys. Any other structure is not allowed. Look at Section 34 of the Legal Practice Act. Also look at clauses 5 and 6 of the Lpiif policy. I know that there are attorneys who tell us that they've been advised by auditors or financial advisors to set up their practices in PTY Limited and to have trusts, and to, I'm not talking about a trust account, I'm talking about a trust as an entity for tax purposes. If you do that, you are breaching the law. Please read the article that's published in December 2024 in De Rebus. Also read the article that was published on firm structures in December 2023. That article on firm structures addresses something else that's pervasive in the profession. You get people saying that I'm not liable because I'm just a salaried partner. I'm not an equity partner. I'm a salaried director. I'm not an equity director. I don't get profits, so therefore I don't. Neither the Legal Practice Act nor the Companies Act make any distinction between the two. In that article in December 2023, the reference is made to recent cases, even a decision of the SCA on that. So if your partner is a partner, director is a director, all have the same responsibilities. Your own internal arrangements are your business. And insofar as the obligation to blow the whistle on your peers, read the article in September 2023. If you hide things that your peers are doing, you may just be in trouble. Also read the article that was published in March 2018 that also deals with that. Then just lastly, when it comes to partnerships, partnership agreements, if you are if you have just become a partner or considering becoming a partner in future, read the partnership agreement carefully. Partnership agreements, don't only read them to know how much money you'll make, how much equity you can take out of the firm. See how it addresses risks. Does your partnership agreement address what will happen if there's a claim against the firm and the firm is uninsured for that claim? Does it address what will happen if you have a claim and there's an excess that has to be payable? Is it only the partner in the department responsible who will pay, or will everybody deal with it? As I say repeatedly, I'm loath to give legal advice to lawyers, but I'll go against my own rule here. Write agreements, write partnership agreements for divorces, not for marriages. As long as things are going well and everybody's making money and nobody cares what's in the partnership agreement. It's when things go wrong that what's in the partnership agreement matters. And I say that a partnership agreement is akin to a marriage. In a marriage, parties go and sign an anti-nuptial contract, go get married and go on and live the rest of their lives happily after. Unfortunately, in law firms, it's not always the case. You don't always just sign a partnership agreement and work for the rest of your life in the firm on a smooth and bumpy road littered with the beautiful flowers and the sweet singing birds. So have a look at your partnership agreement and ensure that it addresses the risks. Look at that article that's published in October 2017 in the Risk Alert Bullet. Sorry, it's published in the Rebus. It calls Until a Claim Do Us Part. Thanks, colleagues. That's the end of section 2 of part 2. We'll see each other again in part 3.